Hi, everyone. Welcome to the latest installment of the Adams and Reese Financial Services webinar series. My name is Amy Hannah Keeney, and I am one of our Atlanta-based attorneys. I also serve as the Financial Services Regulatory and Compliance Team Leader at the firm, and I'd like to welcome you to today's program, which is called Help, My Borrower Filed for Bankruptcy. Now what? With me today are my colleagues, Angela Graywall from our Jacksonville office and Tim Anseberger from our Jackson, Mississippi office. Angela and Tim both focus on commercial restructuring and bankruptcy, and they frequently counsel clients in the financial services sector. Now, before we get started, a little bit of housekeeping. We'd love to hear from you today. If you have any questions during the presentation, please type them into the question box in your control panel. Only our presenters are going to see the questions that are submitted, and we'll have time to address them at the end. Also, we're recording the program today, and we'll be sending you an email with a link so you can share the content with your colleagues. The program has been pre-approved for 1 hour of CLE in 7 different states, and we'll be submitting your attendance with the state bars as indicated on your registration form. Now, over to Angela.
Thanks, Amy. We wanted to start off today by giving you just a brief overview of bankruptcy, the different chapters of bankruptcy, and some terminology that you're going to be hearing throughout the presentation this afternoon. So the goal of bankruptcy is to provide a mechanism for distressed businesses or individuals who are unable to pay their debts and give them a fresh start. It's governed by the United States Bankruptcy Code and federal rules of bankruptcy procedure. So you will often hear references to the code permits this, the code doesn't permit that. The code puts in place an orderly process that establishes a priority of creditors who may be repaid and when they may be repaid. Bankruptcy courts are a court of equity. And 11 U.S.C. Section 105A states that the court may issue any order, process, or judgment that is necessary or appropriate to carry out the provisions of this title. This provision can be used by the courts, and petitioners will request the court use this provision as authority for things that may not be explicitly provided for under the code. We'll talk about a few of them today. Now, you'll often hear about businesses or individuals filing for bankruptcy, but there are different chapters of bankruptcy that have different goals, different processes and procedures. And what a financial institution may want to do or be required to do will often depend on what chapter has been filed. So Chapter 7 is liquidation. A Chapter 7 trustee is appointed. They gather all of the debtor's property that is not exempt under state or federal law, liquidate any assets, and pay a dividend to unsecured creditors. The goal of a Chapter 7 bankruptcy is to discharge all the debtor's obligations, all the debts that are owed to creditors. Often Chapter 7 cases are what are called no asset cases, in which the debtor retains their exempt assets. They can discharge unsecured debts that are due to creditors without those unsecured creditors receiving any payments. Chapter 11 involves reorganization. It's designed to allow an individual, not common, but it can happen, a partnership, an LLC, or a corporation that is engaged in business to reorganize and restructure their debts while continuing to operate and to do business. The company that files is called a debtor in possession because they continue to operate their business during the pendency of the bankruptcy case. Unlike a Chapter 7, a trustee is not automatically appointed. The debtor is the one who controls the case. There are 2 main paths that Chapter 11 bankruptcies take. One is where there is what is called a 363 sale, where the debtor sells off the main assets of the estate free and clear of liens. Funds from that sale may go to paying a portion to the creditors. Any remaining assets may be liquidated or abandoned, or if there really is nothing left, the case may be closed altogether. In another path, a debtor puts together a plan for repaying a portion or all of its priority, secured, and unsecured debts based on its continuing operation of business. So they may be able to restructure those debts, reduce interest rates, pay out over a longer period of time, etc. There is a new provision under Chapter 11 called a Subchapter 5 bankruptcy. It was just introduced this past year. It's designed for small business debtors. It tries to be a more streamlined process and a quicker process for small businesses, so it doesn't have some of the obligations that they would have in a standard Chapter 11. So you're likely going to be hearing more about Subchapter 5. Chapter 12 is for family farmers and fishermen. It's also a reorganization chapter and meant to allow these family farmers and fishermen to operate without some of the burdens of a Chapter 11 case. Chapter 13 is about individual reorganization. Only individuals are permitted to file a Chapter 13 case. The debtor proposes a plan by which a portion of their unsecured creditors are repaid over a given period of time. Typically filed when the debtor wants to retain an asset, such as a car, and they have a job and a source of income so they can pay money to the creditors over time. Some important terminology. The petition date is typically the date that the debtor files their bankruptcy petition. The petition date establishes a strict dividing line between pre-petition periods and post-petition periods. Pre-petition and post-petition are separate, and this is important. You'll see later, because you can do things with pre-petition funds that you can't do with post-petition. You can't use post-petition funds to pay pre-petition debts without an order of the court. The automatic stay goes into effect the moment the bankruptcy petition is filed. There's no need for a court order or for the debtor to do anything further. The automatic stay prohibits any collection action against the debtor or property of the estate. It gives the debtor some breathing room to continue to operate and stops the race to the courthouse of creditors who may be trying to collect on assets the debtor has. Now, generally, the automatic stay applies only to the debtors and not to affiliates or family members who have not filed for bankruptcy. A couple of exceptions: certain co-debtors of a Chapter 12 or 13 debtor, and also a court could order otherwise through its equitable powers, as we mentioned a little earlier. So let's say your borrower, an LLC, files for bankruptcy, but your guarantor has not. Presuming there's been a default and you would have the authority to, under the terms of your contract, you could file suit against the guarantor, and the guarantor may go to the bankruptcy court and argue that the automatic stay should stay that action against them too. It's not common. What you may see it is in a Chapter 11 case where a guarantor argues that the capital, the funds they have, or their presence is crucial for a successful reorganization of their company, and that they should not be tied up in the bankruptcy case. Actions taken in violation of the automatic stay are generally void and can subject you to sanctions if you have willfully ignored the automatic stay. Now, in June of this past year, the United States Supreme Court, in a case called Taggart v. Lorenzen, discussed the appropriate standard for holding a creditor in contempt for violation of the discharge injunction. The discharge injunction prohibits creditors from attempting to collect on debt that has been discharged in bankruptcy. The court held that a creditor could be held in contempt if there was no fair ground of doubt as to whether the discharge order barred the creditor's conduct, but there's no objectively reasonable basis for concluding that the creditor's conduct might be lawful. Now, lower courts have questioned whether the standard should be applied to violations of the automatic stay as well, and you have mixed decisions, some courts concluding yes, some courts no, some courts not addressing Taggart altogether. The best thing to do is just be careful of the automatic stay and make sure that your institution has proper processes and procedures in place for receipt of bankruptcy notices. Now, a lot of stuff is automated and standardized. You need to ensure that there's a process in place to notify all the appropriate departments that might have borrower interactions that there has been a filing of the bankruptcy case. Now I'm going to turn it over to Tim, who's going to discuss how you can lift that automatic stay and get adequate protection.
Thank you, Angela, and that is correct. I'm going to start today with a topic that you just touched on, and that is adequate protection and lifting the automatic stay. Now, as Angela discussed, once a bankruptcy case is filed, the automatic stay prohibits you from pursuing your collateral if you are a secured lender. And that's often troubling and frustrating because you may have been in the process of foreclosing or repossessing on that collateral when the case was filed. The debtor's insurance may have lapsed. The debtor may have failed to pay taxes, or the debtor may be just way behind in payments. Now, the Bankruptcy Code contains two key provisions that protect your rights as a secured creditor. The first is the right to adequate protection under Section 361 of the Bankruptcy Code, and the ability to obtain relief from the automatic stay under Section 362. Angela, if you could hit that next slide for me. Now, I'll start with adequate protection because that is known as one of the most important protections in the entire Bankruptcy Code. Adequate protection requires that a secured lender receive compensation or value during the bankruptcy case to protect against the erosion of your secured status through destruction of the collateral, depreciation, or dissipation of assets. The idea here is to keep the status quo during the bankruptcy case, and it's really a trade-off. If the debtor wants to keep and use your collateral during the bankruptcy case, then they have to protect your security position. So what exactly is adequate protection? Well, it's relief sufficient to protect any decline in the collateral's value, and there really is no set form. But it typically takes the form of either cash payments or replacement liens. But that's not all. It can also be third-party guarantees, requirement that the debtor pay taxes. It can be an order limiting or conditioning the debtor's use of collateral or the operation of the debtor's business. It can also be drop-dead clauses. So, for example, if the debtor fails to secure insurance or pay taxes by a date certain, the automatic stay will lift and you can pursue your collateral. Now, if you happen to be oversecured and have a significant equity cushion, courts will sometimes find that the cushion itself constitutes adequate protection, and that's usually determined on a case-by-case basis. So how exactly do you obtain adequate protection? If it's not negotiated before or right after a bankruptcy in an agreed order, you're going to have to file a motion, hold a hearing, and have the court determine what adequate protection is appropriate under the circumstances. And this usually becomes a battle of the expert witnesses. What is the value of the collateral? How is it depreciating? And what form of adequate protection will be necessary to protect you? A motion for adequate protection should be filed immediately. And if you do so, there's a pretty significant benefit to you. If the debtor fails to provide those court-ordered adequate protection payments, those payments will be entitled to super priority in the bankruptcy case. Angela, if you could hit that next slide for me, please. Okay, the second protection in the Bankruptcy Code that's related to the first I just talked about is the ability to lift the automatic stay to pursue your collateral under Section 362 of the Code. It's also called obtaining relief from the stay. Now, relief from the stay is available under two general circumstances. The first is what the courts call, and the code calls, for cause. And that includes where the debtor has failed or cannot provide you adequate protection. So if you move for adequate protection and there's no way for the debtor to provide it, or the debtor refuses, the court's going to usually allow you to pursue your collateral and lift the automatic stay. The second general circumstance is without cause. And cause does not exist, or, well, in other words, if the debtor has no equity in the collateral and the collateral is not necessary for the debtor's effective reorganization, then under the code that's called lifting the stay without cause. And in those circumstances, it's usually where the debtor has multiple pieces of property and your collateral is one of those pieces that the debtor does not need to continue as a going concern. Under those circumstances, the court's going to allow you to pursue that collateral and lift the automatic stay. Now, relief from the stay is also sought by motion. And typically what you'll do is after the bankruptcy case is filed, you'll file one motion asking the court to both either lift the stay or alternatively provide you adequate protection. and typically both issues are determined at that same time. And now I'll turn it over to Angela.
Thanks, Tim. Want to talk about set off. Non-bankruptcy world, debtor owes you $100,000 on a loan, they've defaulted, you've got, according to the agreement, the ability to set off $50,000 in their bank account. 11 U.S.C. section 553 establishes the set-off procedures in bankruptcy. Now, it's important to note that this is only if you have a set-off right under applicable state law or in the contract or agreements. So it doesn't create a new right if one does not already exist. Also, the debt must be mutual. So it must be owed by and between the same two parties. Now, this is strictly construed. So you can't offset a parent company's credit for a subsidiary's debt or vice versa. Additionally, you can only set off pre-petition debts with pre-petition funds. So if the debtor deposits funds in a post-petition, you cannot use those funds to set off pre-petition debt. You need court authority to set off post-petition. You need to go to court and seek relief from stay, as Tim just talked about, to set off these pre-petition debts. If you have set off after the petition has been filed, but before you have notice of that petition, you're going to have to return the funds. Also note that if you set off in the 90 days prior to the bankruptcy petition in what's called the preference period, you may be subject to a preference action. It's beyond the scope of this webinar, but it is an important consideration. If you get a notice of a bankruptcy and you look back and discover that you did set off in the 90-day period, you may want to contact counsel and see what the potential preference liability is. I'm going to switch it back over to Tim.
Thank you, Angela. And I'm going to just discuss garnishments. Garnishment issues are very common in the early stages of a bankruptcy case. In addition to foreclosures, garnishments are often what can trigger a bankruptcy filing. Now, garnishments are subject to state law, but it's generally a judicial proceeding that involves three parties. The first is the plaintiff, who is the judgment creditor, holding a judgment and seeking payment. They're referred to as the garnisher. The second party is the judgment debtor, who owes the money to the garnisher. The third party is the garnishee, and for our purposes, that will be the bank that is holding the money or property of the judgment debtor. Now, in the proceeding, the garnisher names both the judgment debtor and garnishee as defendants and demands the garnishee pay over any funds in the judgment debtor's bank account. As the garnishee, a lender's role is typically neutral. You freeze the funds, file a response, and wait for a court order directing you on how to handle those funds. If there's a bankruptcy filing, any of the parties can move to stay or dismiss the garnishment proceeding. Angela, if you can turn to the next slide. Now, the key bankruptcy concerns are when the lender is the garnisher seeking the funds and the judgment debtor then files for bankruptcy. The risk here is whether the garnishment proceeding violates the automatic stay once that bankruptcy case is filed. Now, unfortunately, bankruptcy courts are not consistent in this area, so it is important that you are in contact with your legal counsel if one of these issues arise. Now, some courts hold that a garnisher who learns of a bankruptcy case has an affirmative duty to dismiss or stay the garnishment proceeding. Some courts actually go farther and hold that the garnisher must also cause the garnishee to release any frozen funds. These courts typically hold that the failure to promptly take these actions constitutes a willful violation of the automatic stay, and the court may impose sanctions. Now, there are other courts that have held that there is no duty to dismiss or cause the frozen funds to be released, and the creditor will usually not violate the automatic stay so long as they don't take any affirmative action to try to collect any funds. Angela, if you could turn to the next slide, please. So given that uncertainty with the way courts treat these actions, lenders should take a conservative approach when a bankruptcy case is filed and there is a garnishment proceeding pending. The first way to do that is to take prompt action to at least stop the post-petition garnishment proceeding. You can do that by filing a suggestion of bankruptcy, informing the court of a bankruptcy filing, or filing a motion to stay that state court proceeding. And also related to set-off that Angela discussed earlier, if you are the garnishee and are asserting the right to a superior claim or set-off on the judgment debtor's account, seek prior bankruptcy court approval before taking that action. And I will turn it back over to Angela to discuss our next slide.
Thanks, Tim. So what do you do when they're with the deposit accounts of the debtor? Under the bankruptcy code, you're obligated to turn the funds in the debtor's bank account to the trustee in a Chapter 7 case, because the Chapter 7 trustee is the one who's in charge of the debtor's assets. In a Chapter 11 case, assuming that no trustee has been appointed, and they rarely are, you need to comply with the instructions of the debtor in possession, because they are in charge of their funds. If your institution with knowledge of a bankruptcy filing acts at the instruction of a Chapter 7 debtor instead of the trustee, you can be held liable. There is a safe harbor provision if you don't have actual notice or knowledge of the bankruptcy case. So should you just freeze the account? Maybe that's the easiest thing to do, right? Freeze the account and then figure out what you need to do as the next step. So if you are seeking relief from the automatic stay to, for example, set off from the debtor's account, the Supreme Court has held that it is not a violation of the stay to freeze an account pending the outcome of such a motion. If you couldn't do that, then theoretically the debtor could just suddenly transfer that $50,000, $20,000, whatever, out of the bank account. But what if you are not attempting to set off? And this really, again, depends on the chapter of bankruptcy that is filed. Most courts have found that it's not a violation of the automatic stay to place a freeze on a Chapter 7 debtor's bankruptcy account because the trustee is in charge. But since Chapter 11 and 13 debtors get to control their bank accounts, some courts have found that unilaterally freezing them is a violation of the automatic stay. Now, ideally, in a large Chapter 11 case, the debtor is going to reach out to the financial institution prior to filing to help establish the system of how they're going to ensure that pre-petition obligations are not paid from post-petition funds, to ensure a smooth process so you'll know what is coming, so you're not thrown into any issues. I'm going to turn it back over to Tim to talk about checks.
Thank you, Angela. And following up on accounts, your borrower may have a checking account at your institution. And if a bankruptcy case is filed, the first concern is typically who actually has authority to write checks. And that depends on the chapter of the bankruptcy case. In a Chapter 7, it's the Chapter 7 trustee. In a Chapter 13, it's the debtor. And in a Chapter 11, it's the debtor in possession as long as no trustee has been appointed by the court. Now, the second concern is exactly what payments are authorized. Check payments must be authorized by either the bankruptcy code or a court order. And the key issue we see here is where the debtor has written a check before the bankruptcy case is filed, and that check is presented for payment after the bankruptcy case is filed. Unless authorized by court order, payment of those checks is not permitted. A bank will typically not incur liability for presenting or honoring a check so long as it had no knowledge of the bankruptcy case and it acted in good faith. But if the bank received notice of the bankruptcy case, honoring the check may in fact violate the automatic stay. Now, importantly, there is a safe harbor in the bankruptcy code. It's under section 362D11 that provides that presentment of a negotiable instrument and the giving of notice of and protesting dishonor does not violate the stay. So under the safe harbor, the bank may give notice of the dishonoring of a check without violating the stay. And the bank may therefore return all checks dated before the petition date. But it's always safe to make sure there's no court order authorizing those checks be written and paid. So whenever there's a bankruptcy case filed and you're dealing with a checking account, always make sure there are no orders in the case addressing payment of these checks. And I'll turn it back over to Angela.
Thanks, Tim. Talk about credit cards. So credit card processing services offered to merchants who accept credit cards for their payments, typically governed by a merchant services agreement between the bank and the merchant. Now, any exercise of a post-petition set-off against the debtor's account to recover on a chargeback or a return does require relief from the automatic stay. And as I discussed earlier, you can freeze the merchant account, again, presuming that right exists under the terms of the agreements, as long as you're filing that motion for relief from stay. But a court may not grant relief from stay. The debtor, if it's a Chapter 11 debtor, may need that merchant account to stay in business. They need to be able to continue to operate and to accept payments from third parties using a credit card, and may not have the ability to set up a credit card processing agreement with another institution. So instead of giving you relief from stay, a court may simply order adequate protection. Can your institution be forced to continue credit card processing services post-petition? The answer is yes. This is seen as an executory contract that can be assumed by the debtor, just like any other executory contract. The rationale and the theory is that the bank is agreeing to process transactions, not to extend credit. However, to assume such a contract, the debtor will need to cure any default and provide adequate assurances that chargebacks or returns will be promptly cured. In order to establish protections, a financial institution wants to be involved and should be involved in any cash collateral or cash management order, and establish that any credit extended is authorized, that the institution's claim is secured by first priority liens and security interests in the merchant account and reserve account, and that the lien secures post-petition transactions. I'm going to talk a little bit more about cash collateral and cash management orders later on, but these are orders that are established often early on, first day in the bankruptcy case. So it's important to get notice of filing in these Chapter 11 cases, that you reach out to your counsel and get involved on the ground floor. Now, what about credit card issuance? So the purchase card agreement that the debtor's business has, that the employees of the business use for, or did use for, travel expenses in pre-COVID period. So can you cancel a credit card post-petition? Subject to the terms of the agreement, presuming that the agreement gives you the right to cancel, then yes. You are not required to extend additional credit to a debtor in bankruptcy. But what if you don't want to cancel? What if you are okay with them using it post-petition? So the use of credit cards in the ordinary course of business can occur without court approval. It's treated as an administrative expense of the bankruptcy case, which is afforded a high priority of repayment. So often these will be repaid during the pendency of the bankruptcy case as the debtor continues to operate. But the problem is that you, as an institution, can't control what the debtor does with the credit card, what they are using the credit card to pay. So what if the debtor goes out and buys things that are not in the ordinary course of business? Hopefully the debtor, knowing that they're in bankruptcy for a reason and they've got processes in place to monitor, would not be doing such a thing. But if they did do that, those items could be held to be not entitled to a priority administrative claim. So the solution is to condition any continued use of the credit card on the debtor obtaining an appropriate court order. which can be folded into a cash management order or a cash collateral order, which I'm going to talk about in a little bit. I'm going to switch it back over to Tim to talk about automatic payments.
Thank you, Angela. Early in bankruptcy cases, issues often arise when a debtor has been using an automatic payment system to pay its creditors before filing the bankruptcy case. And the issue we usually see here is whether a creditor violates the automatic stay by accepting those payments. Now, you would think there wouldn't be an issue because once automatic payments are set up before the bankruptcy case, the creditor is not taking any action to receive these funds, they're just accepting them passively. But bankruptcy courts have actually rejected the argument that mere acceptance of automatic payments does not violate the stay. So if money is received by automatic payment after the bankruptcy case, it must be returned absent a court order. Now, there are two exceptions to this general rule, and the first is obviously automatic payments may be authorized by bankruptcy court order, and usually if they are, that order is entered at the beginning of the case. The second exception involves where a debtor voluntarily assumes a pre-petition debt. If the creditor has received a, quote, positive indication, end quote, that the debtor intends to voluntarily assume a debt, some courts have held that accepting automatic payments does not violate the automatic stay under those circumstances. This is, however, not a reliable exception. It's court created, it's not actually in the bankruptcy code, and courts have not explicitly defined the term positive indication. For example, there have been some courts that have held that a written letter proposing to reaffirm the debt is not a positive indication. Now, the duty to stop automatic payments after the bankruptcy case is filed is on the creditor, assuming the creditor learns of the bankruptcy case. And automatic payments may later be reactivated to pay post-petition expenses so long as consistent with any court order or court-approved budgets. So the lesson for automatic payments is that you should always be aware of what court orders or court-approved budgets have been entered in a case, and to also, if there haven't been, get court-approved orders approving automatic payments to you. I'll turn it back over to Angela.
Thanks, Tim. So I've used the term cash collateral throughout. Just want to talk about that a little bit. Cash collateral is cash and cash-like property in which both the debtor and another entity have an interest. So to use the cash collateral, which a Chapter 11 debtor needs to do to continue to operate, the debtor must adequately protect the secured creditor's interest in the cash. So Tim mentioned earlier, but most common is periodic cash payments or additional or replacement liens. These are usually negotiated through a consensual order. What you want to be on the lookout for is if a secured creditor has an interest in the cash and that secured creditor is not you, of the deposit bank. You want to make sure that in any cash collateral order, your security interests and liens are not prejudiced. The cash collateral may not be enough to allow a Chapter 11 debtor to continue to operate and to reorganize. So a debtor can seek a loan post-petition, which is called debtor in possession financing or DIP financing. Now there are a lot of requirements beyond what I've listed here, but for our purposes today, DIP lenders get super priority treatment and they may be able to prime other liens and security interests. So the cash collateral order and an order approving a DIP financing are often established early on in the case. I talked about first day motions. These are motions that are filed almost alongside the bankruptcy petition and can be heard, we say the first day because it's really the first day after the bankruptcy is filed or a couple days later. They might file the motion on a Thursday and get in on the basis of, first thing Monday morning. You want to negotiate to ensure that liens granted to another secured creditor or to a DIP lender, if you're not the DIP lender, don't prime your own liens or interfere with your right of set-off. So for example, an order could give a DIP lender a direct lien on a deposit account, and that lien would be perfected without the necessity of filing or execution of documents that would otherwise be required in the non-bankruptcy world. You want to make sure that any order that is entered about the cash management system confirms the bank's right to collect its customary fees and charges from the account funds, notwithstanding any liens granted to other secured creditors. So this is why it's important to be on the lookout early in the case. Some of these orders that are entered, maybe only on an interim basis, but they're entered right away, can affect your lien.
Thanks so much, Angela and Tim. That was very enlightening. Attendees, now is the time to enter some questions. I saw a few questions come in while Angela and Tim were presenting, so I'm going to go ahead and address those. But by all means, if you are listening and something came up during the presentation that you'd like to ask either Angela or Tim, feel free to open up the chat window on your webinar screen, type in the question, and we will handle it. Okay, first question I got. Why would I want to continue to do business with a debtor post-bankruptcy? That's a good question. Angela, do you want to take that one?
Sure thing, Amy. So again, it may depend, like a lot of things, on the chapter that has been filed. But in a chapter 11, a 12, or 13, a debtor is going to continue to operate. They're going to continue to receive funds. You may want to make a DIP loan, for example, because you're going to get a higher interest rate, and your chance of repayment is higher because you're given that super priority status. The debtor may have, been a pretty good customer for you, and you think that they have a chance to succeed in a reorganization. So just because the debtor is in bankruptcy doesn't mean that you don't need to continue to do business.
Okay, thanks, Angela. Tim, the next one is directed at you. You noted that having an equity cushion can serve as adequate protection. How much of a cushion is needed?
So that's a good question to answer. Like a lot of questions in bankruptcy is that it depends, but what courts will do is they'll compare the percentage of the cushion to the value of the collateral, and generally a cushion greater than 20% is going to be sufficient to be considered adequate protection. Now there are factors that can affect that. So if the debtor at issue has very low prospects for actually reorganizing, the percentage will need to be a lot higher. Or if the collateral at issue is declining quickly, like certain equipment, logging equipment, farming equipment, that declines in value more rapidly than other equipment, a higher percentage is also going to be needed. But typically it's 20%.
Okay, thanks, Tim. One more question. What should I be concerned about when the Chapter 11 debtor first files their petition? Angela, I'm going to kick that to you because I think you talked about that a little bit at the end of your presentation.
Thanks, Amy. So yeah, in Chapter 11, those kind of first day motions are crucial. They're often filed right alongside the bankruptcy petition. So they're going to be motions to use cash collateral, motions to establish cash management proceedings, keeping utilities on, etc. Some of this may have been negotiated pre-petition. A debtor wants to operate smoothly, so hopefully they will have reached out to their depository institutions to establish the appropriate protections and processes. But if they haven't, you need to be on the lookout because these are often granted on an interim basis right away. So if the court enters an order on an interim basis and you didn't receive notice in time or you didn't have time to object, it's not lost. You can continue to negotiate before a final order is entered. But ideally, you'll be in on the ground running to get an order that makes sure that your liens are protected, that you still have the right to charge those customary fees, you're protected from overdrafts, and the other things that we mentioned here today.
Okay, thanks, Angela. I don't see any more questions, so I'll call it. But if you are listening and you have a question, please direct it at either Tim or Angela and their email addresses, and we will make sure that you get an answer. Again, we'd like to thank you all for allowing us to present this program to you today and for spending this hour of your day with us. As a reminder, we recorded the session today and we'll be sending you a link and a certificate of attendance for the CLE credit. Those materials will have Tim and Angela's email address on it if you're looking for them to ask them a more specific question. In closing, we'd like to mention that our firm has produced numerous COVID-19 related resources on our firm's website, which is adamsandreese.com. Content is available from the homepage and is organized by subject, including financial services, relief assistance guidance, cybersecurity, employment and business law, and government investigations. Updates can also be found by following the firm's LinkedIn page, Twitter page, Facebook page, and YouTube page as well. Thanks again, and have a good afternoon.